Hi, Dawn Levine here with Georgia Wills Trust and Probate Firm and another video in our Ask Me Anything series. Today, the question is, hey, I created a will online myself. Is it okay? The answer is maybe, but probably not. So why do I say that? Dawn, you're an estate planning attorney. You have a vested interest in saying, no, don't do that. Well, I'm also a probate attorney, and I've got lots of experience with trying to probate those wills that were created online. There's a reason that I am able to make a living at doing this. It's complicated, and you don't know where the pitfalls are. So let me give you some examples that I've actually seen. So we had a probate case where somebody had created their will online, and they probably spent $50 on it, whatever, $100, something like that. They created it themselves. So they had two contradictory clauses in different places in the will. So after they had died, they had one part of the will that said everything goes to such and such, and in a completely different part of the will, they said I leave everything to Susie Q. So that created several possible intentions. You could say that this one was earlier in the will, so this one was probably the primary and the other one was just a backup. Well, they weren't written that way, and there was no language in the will to indicate that that was the intention, so that would have been a guess. Another interpretation could have been, well, they should share it, half to this person and half to this person. Again, it didn't say that. There was nothing in the document to hang our hat on to go with that interpretation. And then, there could have been other interpretations as well. And so how do you work that out? So the answer is that you would have to have litigation, and unless they came to some sort of agreement themselves. So this person and this person agree, okay, we're going to split it. People are not always reasonable. Maybe they would do that, maybe they wouldn't. If they didn't, and probably even if they did, we would have to go before the judge to get the judge to say, hey, this is what they're agreeing to, we need your blessing on it. Because they can't just do any old thing they want to. If it's been submitted to the court has jurisdiction, and if you're not following the terms of the will, you got to get the judge's permission to do that. If they didn't agree, then each side is going to be coming with their attorney to present their interpretation of what the deceased person meant. And, that can easily result in the attorneys going home with all the money. So this was a small estate. That could have easily happened. There was just a piece of real estate and a small bank account. And if we had to litigate this, nobody was going home with anything except the lawyers. And that is a sad outcome. I like to make money. That's not how I like to make money. So in this particular circumstance, it all worked out okay because one of the people was deceased. So there was nobody to argue for this side, and the language was written so that the person had to survive. So if you don't, again, that's another area where it could have been a mess. What if it didn't say that this person had to survive? Then the default is that it goes to their heirs, and who knows what those people are like. And there could be, maybe we don't even know where they are. So there's lots of pitfalls for the person who doesn't know what they're doing. So that everything to so-and-so, everything to Susie Q, those are called residue clauses. And a will should not have two of those. But the person who wrote it didn't know what a residue clause was. They somehow missed this ambiguity, this conflict in what they've written. And that's something that we see a lot. When we have these wills that have been created by somebody, that you're writing your own will. You're not going to the probate court every day. You don't know how the court interprets things. You don't know all the rules about what the default is for interpretation. There may be terms that are in the online will and you don't know what they mean, and so you've misused them. something as simple as per stirpes. It's a Latin term. Who knows what that means? Lawyers. And if you use that or take it out, you may have created some unintended consequences. It's very easy to write something that makes perfect sense to you, but in the legal world, with the broken language that attorneys and judges use, that's going to mean something completely different, or maybe we don't know what the heck it means. So it's not a good idea to create your own will. It's really better for you to have somebody who does this every day doing it for you, so that they're not going to put that ambiguous language in there that could mean 2 or 3 different things. The last thing we want is for your estate to go up in smoke with the attorneys getting all the money. It's much better for you to spend a few $100s to get somebody knowledgeable to create your will than it is for your loved ones to have to spend hundreds of thousands of dollars perhaps after your passing trying to get the court to say, what does this mean? And estate litigation is very, very expensive. It's extremely common for the bills to be 6 figures per lawyer if there's really something confusing going on. So don't cheap out and try to cut corners on the front end. Get a well done will so that your loved ones won't have to fight to get what they were supposed to get. I hope you found this helpful, and if we can help you with any of that, please reach out.